welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the nation. Let's take a look at the headlines. Supreme Court to deliver verdict on Article 370 abrogation pleas on December 11th. Supreme Court dismisses petition seeking direction to limit expenses by political parties and candidates in elections. Supreme Court initiates in reference right to privacy of adolescent in response to Calcutta High Court judgment advising girls to control sexual urges. Supreme Court dismisses application seeking enforcement of Internet Shutdown guidelines. Former DRDO Director Pradeep Kurulkar's bail denied in Espionage case. Now the headlines in detail. The Supreme Court is set to deliver on 11 December the highly anticipated verdict on a series of petitions challenging the abrogation of Article 370 of the Constitution. A 5-judge Constitution bench presided over by the Chief Justice of India D.Y. Chandrachud and also including Justice S.K. Kaul, Justice Sanjeev Khanna, Justice V.R. Gavai and Justice Suryakant decided on the pleas and reserved its verdict on September 5th after an extensive 16-day hearing. The centre was represented by Attorney General R. Venkatramani, Solicitor General Tushar Mehta, senior advocates Harish Salve and Rakesh Dwivedi among others. On the opposing side, senior advocates Kapil Sibbal, Gopal Subramaniam and Rajiv Dhawan among others represented the petitioners. Notably, the constitutional validity of the central government's decision to abrogate Article 370 on August 5, 2019 and the validity of the Jammu and Kashmir Reorganization Act, which resulted in the bifurcation of the erstwhile state of Jammu and Kashmir into two union territories, namely Jammu and Kashmir and Ladakh, was put under the scanner of the Apex Court. During the proceedings, the top court raised pertinent questions, including the authority to recommend the revocation of Article 370 in absence of a constituent assembly in Jammu and Kashmir. Additionally, the court questioned how the provision explicitly labelled as temporary in the Constitution became permanent after the J&K Constituent Assembly's termination in 1957. In response, the centre defended its action, asserting that there was no constitutional fraud in annulling the provision that accorded special status to J&K. The Supreme Court today dismissed a petition seeking a direction to establish limits on expenses incurred by political parties and candidates during elections. The top court's bench of the CJI D.Y. Chandrachud, along with Justice J.B. Pardiwala and Justice Manoj Mishra, firmly asserted that such matters fall within the realm of legislative policy. The petitioner, a resident of Haryana, urged the court to issue a number of directives, including the fixing of an upper limit for expenditure by political parties and candidates, restricting spending in articles printed and disseminated before nominations, and calculating expenses related to rallies during the nomination filing process. The petitioner also sought a direction to all high courts to resolve election petitions within a stipulated time frame of 6 months. The top court rejected the plea and submitted that these are not matters for which it can simply issue directives, noting that there are existing laws in place. The Supreme Court, in a significant move, has taken suo motu cognizance of a case titled in reference Right to Privacy of Adolescent. This action comes in wake of a recent contentious judgment by the Calcutta High Court, advising young girls to control sexual urges and not giving in into 2 minutes of pleasure. A division bench of the High Court, comprising Justice Chitranjan Das and Justice Parthasarathi Sen, on October 18 this year, overturned the conviction of a man involved with a minor girl, asserting that their relationship constituted a non-exploitative consensual sexual relationship between two consenting adolescents. The High Court's bench further recommended deferring the consideration of age of consent under the Prevention of Children from Sexual Offences Act to the Law Commission of India and the National Commission for Protection of Child Rights. It also called for a balanced approach to avoid criminalization of consensual sexual acts among adolescents aged 16 and above. The matter was placed before a bench of Justice Abhay S. Oka and Justice Pankaj Mithal today. The Supreme Court has dismissed an application that sought the enforcement of the guidelines issued in 2020 regarding state-imposed internet shutdowns. The bench, comprising Justice B.R. Gavai, Justice Dipankar Datta and Justice Arvind Kumar, asserted that the petitioner had alternative remedies available for enforcing these guidelines. The bench expressed dissatisfaction with the approach of the petitioner and said that we condemn reopening of disposed of matter by way of miscellaneous applications. Thank you, dismissed. Justice Gavai then acknowledged that issuing notice on the plea was a mistake. The top court on May 11th issued notice on the miscellaneous application, seeking the centre's response. In retrospect, the court's guidelines issued on January 10, 2020, underscored the constitutional protection of freedom of speech and conducting business on the internet. In response to these guidelines, the Jammu and Kashmir administration was directed to review curb orders, with a specific emphasis on not using administrative power under Section 144 of the Criminal Procedure Code to suppress legitimate expression of opinion or democratic rights. In the 2020 verdict, the Apex Court directed the authorities in the Union Territory of Jammu and Kashmir to immediately review all orders suspending internet services and said that internet services cannot be suspended indefinitely. In a recent development, a special court in Pune rejected the bail application filed by former director of the Defence Research and Development Organisation, Pradeep Kurulkar, in connection with an espionage case. Kurulkar's counsel argued that the prosecution case heavily relied on mobile and technology, asserting that it was unlikely for the accused to have tampered with the evidence. He urged the court to grant bail to Kurulkar based on these grounds. The bail plea was opposed by Special Public Prosecutor Vijay Fargade, who asserted that there was a prima facie case against Kurulkar and the offence in question was of a serious nature. After hearing the arguments of both the parties, District and Sessions Judge V.R. Kachare rejected the bail plea. It is pertinent to note that Kurulkar was apprehended by the Anti-Terrorism Squad in May this year on charges of allegedly passing sensitive information over WhatsApp to a Pakistani operative who identified herself as Zara Dasgupta. That was all on today's legal news. Thank you and keep watching Verdictum and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.